So hi everyone, it's Grant Abbott speaking. What I thought I'd do is, because there's a lot of stuff going around about trusts and the ATO attacking trusts and all of that sort of stuff. So I thought it was a good opportunity to go and have a really good revisit, a revamp, a relook at some trust issues, and more importantly, just break down, getting really good feedback on for you guys where we are with trusts. I want to go through the ATO ruling. I want to go through resettlements. Just wait for a second. I've got a voice activated massage chair in my room, so every time I talk, it actually starts to move. It's crazy. So I wanted to, it's a good little session, so please feel free to chuck in Q&As as we go through. So this is going to give you a really good update of where we're at the moment in terms of the world of trusts. I want to look at trusts from an asset protection mechanism. I'm going to look at trusts from a estate planning mechanism, and then I'm going to look at it from a tax perspective, and we're going to have a look at where it all fits in. So that when we're going down the track, I don't want you to be fearful for what's come out from the Commissioner. You can ask me as many questions as you want. There's going to be a lot more stuff on that. But let's get down and look at the different sorts of trusts, how they're impacted, where we're going forward, and just get you on top of a lot of things. So this is these are the sort of sessions that they're revisionist, but they're also important for all of us. So where we're at the moment, I think, is really important. And so from our perspective, it's absolutely crucial that, we're in front of the game, that we know that Bosunac came down in August last year. So they should be one of the first things that we're doing in terms of our clients is going back and revisiting that in terms of asset protection. And again, the trust comes up, and particularly that family protection trust is all important, or as my good friend Mitch says, to have the business side and the protection side quite separately. And I think that we need to draw that, and particularly when we have a look at what transpired over the Commissioner's guidelines in relation to trusts. So what we need to do, though, is we've got, again, this issue that's come up from trusts, and that's starting to hit the headlines, the AFR, and obviously the Ukrainian and Russian war has sort of downplayed a lot of that, but we need to know where that comes from and what the impact is, because essentially it is retrospective. But from my perspective, there's look, I feel there's going to be a lot of changes. It's like any negotiation, you put down your really hard cards to start off with and then soften up. So we'll go through, but we really want to make sure that we're always in this visionaries innovation space. And that's absolutely crucial, because that's where the value is. And I know a lot of you, we get so bogged down in BASs and GSTs and all that. Not me, I'm with Abbott Morley lawyers most of the time. But the same thing as we get down and doing the stuff each and every day. So that, from our perspective, we need to spend time dealing in this area, because that's where the value is for our clients. In terms of trust, most of you I don't need to go through. We have discretionary trusts, and I want to go through the unit trust very shortly. So a discretionary trust generally has the key person being the appointor, and I'll start working towards that resettlement issue. Sometimes that you might have a person called a principal. You might have a person called a guardian. In a child maintenance trust, they quite often call the person the protector, but it's someone who sort of sits outside and is really looking over the whole scheme of things, but they're in control. Many years ago, when you'd set ones up in Hong Kong or some other tax jurisdiction, you'd call them blind trust, because no one would actually see who's behind. So having a chat yesterday with Graham Martin, who's one of our he's super bright, and there's always a lot of our stuff, and talking about even having a company as particularly if you've got younger generation, having even a company as an appointor. So the appointer is the key. Then we've got the trustee. My preference, of course, is always going to be a corporate trustee, just so that you've got that, at least that veil of protection over there. And then, of course, you've got the beneficiaries. So they're the key ones. A typical standard deed, I'm going to show you ClearDocs deed very shortly. would have obviously the appointor. You might find there'd be, one line of level, and we tend to not go that depth. So we've got one level of appointor, trustees corporate, and then we nominate who the principal, or you might see the word primary beneficiaries come in. So we name those, which is okay, but the problem is about naming anyone that if something happens to them, you've then got to go and redirect and rechange and do all that. In the past, and even these days, I still get the question from lawyers is that, well, if we change the beneficiary, if we do that, isn't that a resettlement? And I want to go through that issue a little bit later on to show you it's not that necessarily the case. Now, when we have a discretionary, we've got two elements. In fact, there's three elements that can be passed out to our beneficiaries. The first one is obviously our income. Now, what we're going to have to do is determine in our deed what income means. Really, prior to 2011, the income that could only be passed out was net income for tax purposes under Section 95 of the Income Tax Assessment Act 1936. The problem about that is quite often we'd have a accounting income, which may well be greater than taxable income. So, for example, typically we'd have, if we've got a property, a brand new property, we might find that we have capital allowances, and also we've got depreciation. So if those rates are completely different to what you get in accounting, we might, or in tax, we might find that we've got a disparity between the two. So if you have a look at a classic property trust, they'll pay out tax-free and tax-deferred income, which is essentially, for example, the depreciation of capital allowances. So we need to go into our deed and have a look. Generally, as I said before, most discretionary trusts really before 2012, they just need to be upgraded. And I'm going to go through and show you the process on that. But, my preference is to really go and have a look at if we're going down that process of upgrading, and even if they're like 5 or 6 years old, it's not a bad idea to go through that upgrade process. But now we need to say, well, we're going to upgrade to, if it's a trading trust, is it just going to be a trading trust, or with a discretionary trust, or we're going to make it a leading member trading trust? So using the leading member discretionary trust, which I'll look at a little bit later on, or is it going to be a family protection trust, which we've talked about before, which is our really good silo, a castle that's all protected by the moat. So we can distribute net income or accounting income, and really the trustee should have complete discretion as to what they want to do at any point in time. But the must thing, and your deed must show that, if all else fails, there's no distributions, that the net income comes out. So it needs to be distributed. One of the elements that I would warn all of you, particularly as we're going towards 30 June, is that you absolutely must put in place your trust distribution minutes and have them signed prior to the 30th of June. And the reason I say that is that the Commission is getting very aggressive around distributing to kids and documentation not being in place. So it's if the Commission is after income, that is the easiest form of income, because if he can come and do an audit and says that the trust distribution minutes haven't been signed and executed by 30 June, then it means the whole of the trust is taxed at 45%. Not like the stuff that we're talking about in terms of those rulings the Commission is coming out. We're talking about the whole. So if you don't do that, there's huge exposure there. So again, we'll work on that a lot more when we get closer to 30 June, particularly because we're going to know, who are we going to actually be able to distribute to, whether it's going to be the kids, etc. Now, we can also distribute capital out of the discretionary trust, which is absolutely crucial as well. And we can partition capital. So, for example, one of the elements there under Division 7A, rather than having a loan back, we can partition by way of a subtrust within that discretionary trust, that these assets are to be held on a separate basis for example, if it's a corporate beneficiary or whoever, to get around Div 7A. So that's a good fundamental point there. So to be able to build the subtrust, so that's a transposition of capital being left for just a group of people or one or two people. We then move from the discretionary, which is fantastic, to more the fixed style. And a fixed style is just simply, you can write a deed that says, look, all this money is to be split proportionally between these people, so on and so forth. What we've tended to do in the past is we've moved away from having a true fixed trust and moving towards a classic, if you look at it really, fixed trust is a will. Inside the will, we've got the executor, who's really the trustee of the estate, and then must distribute like certain percentage of this person, certain percentage of that person, dollars here or this asset there. So that's a classic fixed trust. But really, probably the last 30 years, we tend to use unit trusts instead, because it's a lot easier, for people to sell units in, units out. And that really comes from the funds management industry, which really, started up in the early 70s. Now, in terms of when you go on LightYear Docs, really, if you're using a unit trust, you just got to be careful. If you're using a fixed unit trust, and this is useful for New South Wales for land tax, because in land tax, all trusts are actually grouped together for that land tax threshold. But if you've got a SMSF or you've got a fixed unit trust, then if you hold that in New South Wales, that's a separate entity. So you get another lot of tax-free threshold, which is fantastic. The only issue though is when it's a fixed unit trust, whatever's in there has to then only go to the beneficiaries. So even vesting, it has to go back on a pari passu or proportional rate to the unit holders. Likewise, you can't have classes of units. You can only have the one focused unit trust. So that's a fix. So just be really careful, because I've had to undo a couple of transactions where people have used the New South Wales fixed unit trust as a unit trust for really a property development or an investment syndicate or whatever. You don't want to use that. You just want to use our non-fixed unit trust, because that enables you to put in a whole lot of classes and doing all that sort of stuff. But likewise, when we do use the unit trust, we're obviously going to have to pay our income and capital across all those units. If you're using as I said, our non-fixed unit trust, then you can create different classes with different units and different entitlements, so on and so forth. Hybrid trusts are generally, again, a mix of both. So to think of it easily, it's like one of our non-fixed unit trusts. So it's a unit trust, but the unit holder has an ability to, and so it's not the trustee, the unit holder has the ability to tell the trustee where that income is to go. So if you look at it, it's like a fixed unit trust with an underlying discretionary trust there, which is quite useful. Now, when we come around to this, and we get this question all the time, can we have a resolution stating the percentages instead of dollar values? Absolutely. So if you have a look at that's a really good question, Daisy. Good to see you again. You'll find in our trust resolutions, you can just put percentages. And particularly after we had a look yesterday in terms of this isn't about Div 7A, but Div 7A, where we've got a corporate trustee, we go down to a bucket company. If that money's left inside the trust, then there's obviously a UPE. A UPE, if we go dollar terms, that entitlement actually starts from the time of the distribution, which is always 30 June. You can't do it later, otherwise it means you've stuffed up your distribution minutes. So it has to start at 30 June. Then obviously the next year you'll lodge your tax return, you'll put in the loan then, and then obviously you'll start paying at a later stage. Whereas if you're doing, as Daisy's pointed out, if you simply do a percentage, if it's a company and we've got the trust holding the UPE, then it actually comes up to the date when the accounts are actually determined. And at that point in time, that's when that UPE actually crystallizes. So again, that's a really crucial point that we've got as to when timing's out. And that's part of the draft ruling. I don't really brook any problems about that. But again, we've just got to get it into our mind. And that's why we're at this early adoption phase. We need to know now that we've got to do a percentage for company, or if a trust is a beneficiary, as opposed to or any beneficiaries for that matter, as opposed to a dollar amount. So just remember, dollar amount is going to kick in your Div 7A loan a lot quicker. If we go down and have a look, this is an important one because I've actually heard on the from a number of our people that usually when we settle a trust in Australia, we don't want to have the set law being part and parcel of the deed compared to everywhere else. Like if you're over in the US, you settle the trust, everything's okay. Same in the UK, all other jurisdictions. Unfortunately here, and I'll just take you through, it's really needs to be a figurehead because Section 102 for revocable trusts, which essentially all of our trusts generally are revocable. Irrevocable means once you put it in, you can't amend it. So here we've got a revocable trust, and basically says where a person created a trust in respect of any income or property, including money, the person has power, whether exercisable, to revoke or alter the trust so as to acquire a beneficial interest in income derived by the trustee during the year of income or the property producing that income or any part of the year of income, which generally is going to be, for example, the trustee themselves or the trustee with the acceptance of the appointer or the principal, or income is under that trust in the year of income payable to or accumulated for or applicable for the benefit of child or children of that person who's under age 18. The Commissioner may assess the trustee to pay income tax under this section. The trustee shall be liable to pay the tax so assessed. So again, these are one of the dangers that suddenly the trust gets taxed at the top marginal rate. So when we have a set law, we generally have them in for a very, it might be the receptionist, might be someone there, and they just settle $10 for that. And then effectively you're off and running. So the set law, you don't want to make your client the set law because otherwise Section 102 might poke its head up. So let's go and have a look at some important themes, and we're getting down to updating deeds very short. I'm going to show you what to do. So when we have a look at our important themes, obviously the beneficiaries, and this is crucial. If it's it doesn't matter whether it's a unit trust, a hybrid trust, or a discretionary trust. Remember, we've got the appointer or the principal, and then we've got the trustee. The trustee controls this on behalf of the beneficiaries. Now, in that instance, we've got a position that, and it's been held in a number of tax decisions, that the beneficiary themselves has no right or entitlement to any specific asset in there. There's a right to be distributed, if it's a discretionary trust, an amount of income or capital, but that's at the discretion of the trustee. If it's in a unit trust or it's in a fixed trust, then there's going to be a certain amount that can be distributed of income and capital, but not assets. Now, you can distribute income or you can distribute an asset being capital, but there's no entitlement. You can't, as the unit holder, as the beneficiary, you can't if it's discretionary, you can't go and tell the trustee or force them to even distribute to you. You can't force them to give you a certain percentage of those assets. So there's no entitlement to any assets. So that trust is broken. With the deed is governed by the law of equity. So when we have a look at it, you're going to find there's the Trustees Act for each jurisdiction. And that will then really guide how those trustees are to behave. And the trustee will then choose the relevant jurisdiction that they want to belong to. And as we've said before, with South Australia, the rule against perpetuities doesn't apply. So I'm looking at getting a little compendium of papers together on why the issues that if we do choose South Australia, why the rule against perpetuities doesn't apply and so on. So we'll look at that a little bit later on. But essentially, when we do a discretionary trust, the deed is the law. So for example, if the deed only allows me to distribute net income, I can't go and distribute income that is not in net income. I can only distribute what is required under the deed. Otherwise, the beneficiaries and everyone can then have an action against me under the law of equity or the relevant trustee act, so on to speak. So again, we need to know what's in the deed. We need to know why it's in the deed and the importance that it's in there, which is why, so for example, it's very unusual. You're not going to find really for most lawyers or certainly online deed providers, we've got leading member trusts and we've got family protection. You're not going to find those anywhere else. You might be able to go and get one drafted up, That of course, if you went to a lawyer and said, okay, this is the key criteria, you're going to be up for like $5,000 or $6,000 as they try to work out what to do. But now, just being part of LightYear Docs and the Abbott-Family stable, you've actually got this full range of trusts, and each of them have a different timing, different position. If you haven't seen my family protection trust session, I'll make sure that Chris has a link in the email that comes around today in relation to that, because again, that family protection trust is becoming all the more important. We talked about the rule against perpetuities. I'll be coming out with something on that one. And what we need to do is, if we have a look at commercial nominees and also Clark's case in terms of updating discretionary trusts, it was really until around about 2010, particularly Clark's case. In fact, we had some really good luminaries for about 10 years on the bench there, some really hardcore tax guys. It was always the basis that effectively, if we made any significant changes to the trust, and I was taught this when I was a youngster, that effectively that may create a new trust. So that if you break down the terms like beneficiaries, like if you got rid of, if you said, okay, this is the class of beneficiaries I've got before, and then I clean out that beneficiaries, I put a new class of beneficiaries, you say, well, hold on, that trust looks completely different. And so then you can imagine what the commissioner would say is that, okay, well, that means it's a resettlement, you've started a new trust. And particularly the commissioner would utilise this when there was tax losses inside a discretionary trust. So effectively you could, someone come in and inveigle themselves in the discretionary trust, pump in income to take up those tax losses. So this went to court, full federal court, and many of the justices there are, ex-tax guys like Dick Edmonds. And they basically came up and said, look, a trust is a trust. Once you establish the trust, then effectively it's always going to be there. So it's like putting a foundation on a house. You might knock it down and put a new house on, but it's still got that foundation. So it enables us to change the rules, change a lot of stuff around that trust. Who's going to be the beneficiaries, who are the trustees, who's the principal, change the perpetuity period, change it to South Australia. And before we would have said, hold on, the commissioner was, well, hold on, if you do that, you're not in this house anymore, you're over here. So therefore, that means that if you've got properties here, they're now vested over there, or they're now really transferred there. So there's going to be stamp duty and capital gains tax. But that's why we're always reticent about this resettlement. I still see this all the time when you're dealing with family lawyers or whatever. They're always saying, well, isn't that going to be resettlement? Isn't it going to be resettlement? And you just say, look, have you looked at these cases? Have you looked at Commissioner's Ruling 2012/21, which basically says we can resettle. What we need to do, though, this is our foundation, and within that foundation, there's going to be a rule that says, well, if you want to change up here, then what we need to do is we need to make sure that it fits in line with that rule. Otherwise, it means that there is a resettlement. And again, just have a look. We're not going to have time to do it, but what I wanted to do is just show you what that would look like. Here we go. So this is a Clear Docs deed. And while it's loading up, I'll just do a couple of questions. John, there's a school of thought that the settlement of a trust A needs to be a physical handing over of money from the settlor and ideally witnessed by a third party. B, the account should not be the settlor. The reason that is that there's a few, again, the school of thought, John, is that essentially that you may not be able to be the advisor on the trust, but I think it's a fairly esoteric. And the settlement sum should be sufficient to cover the stamp duty on settlement and the trust. Otherwise, it's technically insolvent. I would say that that's not necessarily the case, but we do obviously, if we have to pay stamp duty, we can put that in as a loan account, a beneficiary loan account, if we need be. Generally, we do $10. One of the ones that we are looking at doing is when you get a trust from us, and I still have to work out how I'm going to do it, but there'll be a promissory note there that will be issued by the settlor to it's an open-ended promissory note, so it's not on demand. and that effectively will then settle the trust. If you do an upgrade of a trust deed, can the revised deed be the South Australia to overcome? Absolutely. So again, John, we can change jurisdictions. I haven't put that in the facility on LightYear Docs as yet, and I'm going to cover a couple of elements around that one. So John Apolloni again, what is your opinion in ATO view of when doing a trust distribution resolution, having a general clause which states that corporate beneficiary receives all other trust income to which no other beneficiary becomes presently entitled, therefore managing a situation when the ATO deems the dividend to be invalid? Yeah, look, I agree with that one. So I think there needs to be a fallback from what we've seen from, again, all of this is intelligence that is happening in real time. Now, given the impetus that the tax office is giving to family situations and not companies, then we do need to have a fallback. Remember, prepare for the worst, and if you don't, then the worst is going to happen. I just flew in to Sunshine Coast, and everywhere is just absolutely awash with water, and obviously that's coming down. So again, I think that's a great idea, John, and we'll certainly be doing that a little bit later on. For those of you who are part of SEPEPA, I've got to send out this week, and if you can remind me, Chris, I have to send out our session on family provisions. So I'm not sure whether I'm going to do family provisions or we'll go and have a look at this trust, or we'll have a look at a bit of both. But anyway, we'll cover that, because our first free get together, it's a 3-hour session on family provisions claim, is coming up in March. So I'll just see how we're going. So what I need to do is, I've got here nice discretionary trust, Clear Docs 1, made by Maddox. So what I need to do is just, I don't go down the table of contents, and I want to get rid of this, and I want to upgrade it to a LightYear Docs or an Abbott-Family. So what I do, the first thing I do is I look at the variation and termination of the trust. So that's on page 12. Now, there's just a couple of issues around this that we've got to be really careful of. And I've seen lawyers there's been a couple of cases where lawyers have actually stuffed up in this area. So we don't want to get caught. So variation termination of trust, which you can basically see there. The trustee may vary this deed at any time before the vesting day. And that's, again, the rule against perpetuities, even to the extent of revoking, oh, I don't know what's happened there, all trusts it establishes. The trust must do so by executing another deed. That deed may reserve this power of variation, which means you can just do exactly the same. So you can just, the new deed, you can do a variation, or you can't. Now, that's okay. So what I'll do is I just want to show you, I'm going to jump into our system. Oh, sorry about that. Let me go out. I'm just going to jump in and show you how to do the deed. And it should only take you hardly any time whatsoever. So you can actually see there, we use Surge at Abbott-Family to run our whole business, which is great, just as a good system. It's much better than Leap. So what's happening here is I'm going to just do a basic template. And then I'm just going to choose the trust. So what I need to do is just an upgrade of a discretionary trust. I'm just going to do the basics without going through family protection trust or leading member trust. So when I go down here, I'm just going to go, it's not trust establishments, obviously it's trust maintenance, because I'm not establishing. So here we go. I've got upgraded discretionary trust to the leading member. Upgraded discretionary trust to leading member, non-foreign person. Now, just be very careful. If you're in a state where, and the trust is going to have property, then you want to make sure that you have choose the non-foreign person. Otherwise, you'll be up for a surcharge, and potentially, depending on the state, it's a surcharge on stamp duty and also land tax. We've got, there you go, Daisy. I know you're a strategist member. Go, and John also, go and have a look at our trustee trust, discretionary trust distribution minutes. And have a look at that. We've got deed of succession appointors, change of trustee. This is a good one, changes of discretionary trust positions. So, and you guys are lucky that you're on here. This one is a multi-purpose document. So you can retire a beneficiary, you can add a beneficiary. You can retire a principal, add a principal. You can retire a appointor, add a appointor. Same with the guardian, same with the leading member. You can change the trustee here as well. You can also change the name of that discretionary trust. And in there, I'm also going to put in there the ability, I don't think I've put it in there yet, the ability to change jurisdiction, for example, to South Australia. Declaration of trust, that's, for example, if you say, Grant, look, I'm going to go an auction, I want to put something in your name just for a period, then you use this. So this is the upgraded discretionary trust. So I'm just going to put here, Smith SDT upgrade. And I'm going to put that into my, I'll just put LightYear Docs test. So I'm going to start the interview and then that will pop up. And I've got all the relevant folders here. Once we link in with XPM, it's going to be a lot easier to just jam all the information. But really, by the time you fiddle around with that, you can put all the information in anyway. So I've got my Smith upgrade. I put my logo. I'm not going to put the logo in here. So what's the name of the trust? So we're going to call it the Smith, Smith Family Trust. When will what date will it be varied? I'm going to do it tomorrow. We have to put in there what date was it originally created. So again, as I said before, I've just used 2004. 2004, and we'll use the 2nd of March 2004, you need to upgrade your D. Anything prior to 2012. Okay, South Australia. So that chooses South Australia. So that changes your jurisdiction. At the end of the period, you can just put not applicable. So this is really at the end of the day, if you get to the rule against perpetuities or when you vest and there's no beneficiaries that are entitled or prior beneficiaries entitled, ours is quite a lot. So there's property left in the trust. You don't want it to go to the government. So you put in place a charity if you want, but because it's chosen South Australia, it's not going to vest like that. Okay, so under what rule, clause or rule, does the current deed or governing rules allow the trustee to upgrade the deed? So all I need to do is I need to just go in here and I can see there it's rule 53. So, oops, where am I? Okay, so it's going to be rule 53. Now in this one, it's only the trustee, but quite often you're going to have a clause in there in some of your deeds that might be the appointor, or you need to get the sign off the appointor or the principal or the guardian. So you basically put it all in there. Has the trust been varied in the past? If it is, then you just put the dates of variation. Is the appointer joint appointor? No. And then I go to next. So the trustee is a company. I'm just going to put in there Smith nominees. Put in place the 1, 2, 3. And at some point, I'll just throw in any address there. 5 Smith Street, Sydney, New South Wales. As you can see, although I'm choosing a jurisdiction. And I've got sole director there, and I'm just going to use John Smith there. So I like, there's a little function in Google that just maps all the things that you've done before. So I find it a lot quicker than pulling in data. So just make sure that's on. You've got to add the details of the appointor. So I'm just going to have John Smith in there from New South Wales. Now, I can, so there you go, see save address. So make sure that's on when you're using your Chrome. It just makes things so much easier. Now, that's my first appointor. If I want to make a joint, I just go confirm and add next, or I'll just go confirm. Yes, there's going to be succeeding appointor, absolutely. So what am I doing? Sorry. So the appointor is an individual, and I'm just going to use myself. I'm going to use myself, Grant Abbott, 3 Ellery Court, so that's Queensland. And then what I'm going to do is I'm going to confirm, and then I can add another one if I wanted to. So third one, I might put in there, okay, third appointor. And as you can see, you can add companies as appointor. So I'm going to put appointor. I'll put in, there goes a nice little one. And again, we'll just use 5 Smith Street. Now again, sole director, and we'll just use Neil Bell. So that's a good one. Okay, so we've got that, we've confirmed. So I've got 3 levels of appointor there. So the next one I'm going in, and remember, I can change everything in that deed. So if I want, are any of the primary beneficiaries an individual? We'll go yes. Remember, if it was a leading member of Family Protection Trust, it'd be no. So add individual beneficiary, and I'm just going to go John Smith. And so he's the only beneficiary, and then that will pick up anyone aligned to him as well. So I'll confirm that. Are any of the primary beneficiaries of the company? Well, if I've got already here a bucket, I'd go, yeah, I've just got here, bucket there. I'll just change that. And then 5 Smith Street again. So I just put that in, and that's it. So that's how easy it is. So I'm just going to go confirm. I'll put my corporate beneficiary. Are any of the primary beneficiaries an incorporated association, which is charity? I'm going to go no. And you generally don't want to do that anyway, not with a commissioner on the warpath in terms of distributing to tax exempts. So we don't want to be in that position. So with this one, I'm just assembling the document now, and up it'll pop. We can send that off to us for review. If you're a bit worried, and I just want to show you something here in terms of the clear doc. The problem with this one, so I've read here, and I don't want to go in. Trustee may vary this deed, so that's okay, but you need to look at all of the variation. Variation not to cause vesting after vesting day, that's fine because we've actually changed the jurisdiction. Now, this is one here. So this is okay, variation not to allow benefit to a foreign person. That's okay for, but you don't necessarily want to do that if you've got no property, etc. Time variation, altering termination date, so that's fine. Then what we've got here is we've got this little clause here. So you're not allowed to, the trustee may not vary clauses 37 to 41. Now, if that's the case, because I've taken you through what ours looks like, because there's, you need to have, and I'll show you what it looks like. I think it's here, not there, where is it? Right, there we go. So I've completed this one. And what I would be doing is I'm going to show you what the document looks like. So I'm going to download it, and you can have a look at it through this. Go and try these. I mean, particularly discretion. So a variation of the Smith Family Trust, a strategic. Here's your deed of variation. We've got the trustee, the appointor. I'm not sure, I must have missed out on putting who the appointor was. I've just got the successor appointer. So that was my fault in there. So when you see something like that, it just means I must have jumped that area there. So I'd have to go back and check. So I've got the successor appointor, and then I've got the second successor appointer, which is fantastic. We've got the trust established here. When it was established, the appointer and trustee have agreed to vary the trustee. So that, although we only need to have the trustee, it doesn't hurt to have the appointor there as well. Now, what we should have in here, we've got the recitals, inclusion as operative provisions. So all of those ones. We should also put in there, and again, so because we trying to fit everything into a box, the ability to include the exclusions, for example, the deeds, the clauses that we saw under here, that we're not allowed to vary clauses 37 to 41. I haven't been able to jam that into our document. So in that one, what I would do is I would pass it through to request a legal review along with your early deed, and that way then comes
Grant, just as well, just a tip for LightYear members and people that are looking to become members. Let's say you did stuff up part of the document, which Grant just did. I've got to give you some training, Grant, on how to update the deed. I'll do that later, but anyway. So when you go to the action button, you can just relaunch the document and just do a quick amendment without re-entering all the data. So you click relaunch, you go to the part where you stuffed it up, which is the appointer, put that data in, and then relaunch document. And that's without redoing the whole document again. Everyone's going to stuff it up, especially if you're going from a clear docs deed, a reckon, now infinity deed. You've got to get the variation clause right. This is a big question that always comes up, Grant. How do you find the variation clause of the particular deed as well?
Yeah, again, just go into the, as I showed in the Clear Docs one, just go to contents page or index page. And then effectively from that, what you do is just drill down into the requirements for the variation, but read them through. And if you feel as though, like the first bit of there with the Clear Docs is really easy because it just said, you know, the trustee can effectively change it. So that's fine. But if there's a couple of little wonky stuff there or exclusions, then the best thing to do is send it off to Abbott-Family, and then what we can do is go through that process, because you don't want to go into a situation that you don't upgrade, you do the deed upgrade, but it's not in line with the original deed. It doesn't mean necessarily it's a resettlement. It just means that that later deed that you've done is invalid as to those specific clauses.
Okay.
Catherine, I sent you through that Canberra property today. The upgrade template clause I used, if I go back here, good question. Just bounce out of here. So what I did is I went in here, and you'll see that if I go back to what Ben's going, if I go to my templates, and remember, upgrade is not establishments. So we're going to be looking at the bottom here. And if I go down here, templates are loading up. You're going to find it's in here, trust maintenance. Now, when I go through this process, I can upgrade a discretionary trust. If there's property in there, we saw that was embedded in the Clear Docs. But if it's in a discretionary trust, I can upgrade to a non-foreign person. And the reason we do that, particularly we've done a lot in New South Wales, etc., is that if you don't, it's really strange the way that most OSRs and the duty laws apply is that it assumes there that if you've got a discretionary trust, you can distribute to everyone, including a foreign person. So hence, they'll hit you with a surcharge if you buy a property of anywhere between 7 to 9%. And in some jurisdictions, you have to pay extra land tax of up to 2%. So what we want to do is if there's a property in there, we want to make sure it's a non-foreign person discretionary trust, so we don't get hit with those things. If it's just a trading trust, then we don't have to worry about that one. Discretionary trust, we can upgrade to a leading member discretionary trust. That's a really good one I like to use. If I've got an existing trading trust, I still want to make sure I've got that leading member, that strength and that concept. We've got the discretionary trust distribution minutes. We went through, remember, change a trustee for discretionary, change the discretionary trust positions and name. That's our all encompassing. This is the one I used here, Catherine, upgrade of discretionary trust to a LightYear Docs strategic discretionary trust. We've got an ability to vest the trust if we want. We can vest a unit trust, which is a new document up there as well. And then again, if this one was for property, then I'd use the upgrade discretionary trust to a non-foreign person discretionary trust, and I can add designated beneficiaries. So that's a good one. So that's what I would use for that one, Catherine. John Stitt, by 30 June, trust distributions have changed tax situation due to ATO order review clause and named the beneficiary distributions usually the same as the original beneficiaries. That should be okay. John, if I apply with an old deed that has more skeletons than a cemetery, can a new clone trust be established avoiding CGT and stamp duty? No, unfortunately can't. Commissioners issued a ruling on that cloning. So you've just got to be really careful of that, because a clone is a brand new trust setup. What I would suggest is that if you've got a lot of skeletons, just upgrade the deed anyway. But I know what you're thinking. Let me have a think about that one. John, can you convert a discretionary trust to a fixed unit trust and vice versa? Yes, you can. There's commissioners' guidelines out on that one. So again, we can change the discretionary to a fixed to discretionary to hybrid. So again, remember, it's the foundation, which is that original deed. And again, having a look at that Clark's case and the ATO guidelines, virtually can change everything. Francesca, hi Grant, with a variation clause number, what if you've done a deed of variation before the current variation and the variation clause number is different to that of the original deed? The problem about that one is it means that second, and where they pick it up, and quite often, well done if you picked it up anyway, Francesca, is that quite often you're going to get that picked up from the when you go to the bank, because the banks would just going to, if you've got a discretionary trust, they're going to go through all your deeds, and that's just, you know, that's the way they make their $2 to $3 grand out of making an element. So from that perspective, what we need to do is there's two ways. We can go back at this stage. We can go back and ratify that the deed we did, the deed of variation, is effective, notwithstanding the clause is wrong. So we do a deed of rectification. This is the clause, and then we ratify or confirm that upgrade is to take place. Or alternatively, we do a deed of cessation, so that deed really is ceased from ab initio. So we have to go back to the earlier deed. Probably the preference is that, because you've been relying on the new deed, is to do a deed of rectification and deed of ratification. If you need any of that done, just go through to Chris and she can put it on through Abbott-Family as well. So that's a good question. Fantastic question, Francesca. So in what situation would you use the leading member trading trust? That's a really good question, Paul. I just feel that the way we've been using the discretionary trusts are fairly problematical, as you just saw when I did it, is because I'm putting in named beneficiaries, and that's pretty typical. Whereas if we're using a leading member, remember it's past, current, future leading members essentially are the principal beneficiaries, so that it starts to put them in by way of a position. So for example, if I got rid of some leading member appointors or successor ones, put in new ones, then suddenly the whole complexion of that trust changes. So my preference is, and remember it's bloodline for that leading member. With that one, it's a matter of talking to your clients, is that do you want just your basic testamentary trust, or you want it to go to bloodline or any entities that are controlled with the bloodline, which might include a multitude of companies. I've got to have a chat with you today, Paul, or early tomorrow about that documentation being doing, if that's okay as well. Got a bit jammed up because I've been over with Mum for the last week or two. So that's how to upgrade the deed. As I said before, all you need to do is just find those variation clauses. I just pulled that Clear Docs off, straight off the internet, so that was very easy. If I go and have a look at the deed that we got here, so this is a good issue of how do I find the thing. So here we've got a discretionary trust. I want to actually upgrade this one. So I'm going to go through here. You can see there I've got the, I don't know why that appointed didn't come through. Maybe I need to get Ben to give me a bit of help there. If I go through here, and then I'm going to have a look at the variation clause, which I think it's down at 13. Oh, sorry, amendment. So it's either going to be a variation or amendment. So when we have a look here with the amendment clause, we've got here, at any time from time to time prior to the termination date, trustee with the written consent of the appointor, the time being made by deed, or to revoke or alter any trust provision. So that's the easiest one, and that's why we've got the appointor in there as well. My preference is always get the appointor, so it's very easy to upgrade from our one as well. Now, I've got about 10 minutes left, and I'm not going to have time to go through all the bankruptcy, estate planning, but you know my feeling around trusts. You know, I love them to death. With the tax minimisation, when we have a look at it from that perspective, we've got the ability to do income and streaming from 2010. Deeds before that date don't allow the streaming, and 2011 they actually allow capital gains and franked dividends. Bucket companies are great as well, and particularly given the Commissioner's issue around trust distributions. I just want to go in for a little bit of a ride in here in relation to Section 100A. You heard me talk about it yesterday, and I just want to go through the original laws, and I think the tax office are coming in and fitting these laws to current positions, and I want to just go through that one. But essentially, the prior one there would be that we had a discretionary trust. We might have Grant as the appointer of the discretionary trust, the trustee. I distribute down to Chris's charity. She's tax exempt. So effectively what happens is there's no tax payable. But what we have is an agreement off to the side that Chris says, oh, what I'm going to do is I'm going to lend you this money at zero interest and then forgive it after a period of time. Or I'm just going to make this payment to you, or I'm going to, out of this $100,000 you distribute to me, I'm going to put in $99,000 into another trust for you. So there's an agreement or an understanding between myself and Chris that I'm not going to distribute it to her for that because I love her charity, but I've got some other agreement in place. And that's what the original laws were. The key areas here that I've gleaned from the cases are first that in terms of Section 100A, we need to have an arrangement or understand at the time of making the distribution to the beneficiary who's involved. Now, this doesn't stop us distributing to children or adult children or to companies or whatever. So again, the trust laws allow us to distribute to everyone. What Section 100A is, and I think a lot of people are missing it, I can distribute to my children, and then there's a UPE that is now created. Remember, we went through that UPE before, depending if it was a fixed dollar amount, then it's going to be on 30 June for the year. Otherwise, if it's a percentage, then it's going to be when we actually do the accounts and determine it. So from that perspective, it's when the monies, so for example, if it goes to a child and then child's got like, $50,000, we pay $50,000 to the child, and then the child goes and gives their parents $49,000, then with no strings attached, then that's where you're going to get caught. But if, for example, it's an adult child and they're living with their parents say, hold on, well, we've paid for this for you, your school fees, blah, 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 education fees and all that. This is provided they're adult, then effectively you can reduce it by that. So it's where there's that gift or that going away, that's where it gets caught. In terms of minors, the issue around that one is obviously trying to get adults and recover for expenses for when they were minors. The Commission said, well, that's just, unless you can prove it, it's a bit of a falsity, because really as a parent, you're up for all expenses, which I sort of disagree with, but we need to make submissions on that one. So we need to, though, in Guardian case, we need to go and have a look at what the understanding was. And in the Guardian, in Prestige Motors, the way they did that, it was they had a business and they're in selling Toyota cars at Peronis. They had a multitude of businesses. They put money into the trust, and then what they did is they sold the trust from outside into, this is pre-CGT, from outside into the trust, and then they distributed from the trust. But what they did is they distributed first off to a trust with tax losses. And again, there's not a drama about that. But in this instance, what happened is there was a recompensation or a loan from the beneficiary to other members of the group or the related group at nil interest rate. Likewise, then they went to National Mutual, who had a tax-exempt policies, said, look, we're going to pay you over the next 5 years, we're going to pay you $7 million. And because it was going into their life annuity business, it was tax-exempt, but National Mutual had to then go and subscribe for those units. So they did a completely different set of units. And then what happened is that money was then lent tax-free or interest-free to all the rest of the group. So again, there was an understanding, you're paying it to a beneficiary, but a beneficiary is effectively, for those distributions, the beneficiary has an understanding and agreement with someone else who, if they were actually taxed themselves, would be up for a higher rate of tax. So again, it doesn't prevent it going to children, doesn't prevent it going to parents. The problem is if they've got a UPE in there, and that UPE, it really needs to be evidenced by a loan with interest, so it's always on the books. But that way there's a genuine loan, much the same as there is with, for example, Div 7A loan. But what you've got to just be careful of is if that money is then lent out to the parents or just gifted over to the parents, that's where the potential problem is for Section 100A. But there has to be that agreement at the time of making the distribution. So, for example, I would argue, and certainly something that I'll be making through SEPEPA, is that if we've got a child now who's got, let's say, $150,000 UPE, should be a loan, that if that loan is then gifted or the loan is forgiven, then that shouldn't be an issue because that loan wasn't contemplated at the time those distributions are made. Whereas if and again, the commission comes out because that's in the blue zone, so you have to prove it. But in that instance, if you go each year and say, okay, well, I'm going to put it in gift, then potentially if there's that understanding agreement, that's where your issue is. As I said, you must show that another person's going to benefit from that arrangement. So that again was remember the charity receiving it and then money going elsewhere. There has to be a tax reduction purpose. In the Guardian case, they went through and had a look at why the trust was established. And essentially it was driven from an asset protection and estate planning perspective. And I'm going to show you really thing that we all must focus in on. Once you've done that, what we need to do is Section 100A, the Commissioner's got to imbue that it was done for a tax reduction purpose. So if it's done asset protection, if it's done estate planning, if there's a current UPE for a child, I would argue that if that UPE sits out there, that child, if they're in a family law action or if they die, then essentially it's exposed. So we might want to be able to taking that UPE and putting over into our family protection trust. So it's sitting over there, it's going to be for our estate, so on and so forth. And notwithstanding that, so it's quite a few hurdles. One is that when you do the distribution, there must be agreement and understanding. Secondly, that someone else is going to benefit from it. Thirdly, it has to be done for tax reduction. And then fourthly, all ordinary family and commercial dealings are excluded. So it's quite a high bar for the Commissioner to get up, but I think a lot of people are probably reading a bit too much into it. I talked about prestige motors, and I'll send all these slides through to you. Sorry, I'm just running ahead of time. Guardian, same thing. That was a really good, again, a fantastic structure. Go and have a look at Guardian. I think it's a fantastic strategy. Mind you, the Commissioner in these guidelines basically said, look, a lot of the stuff that is put in those draft rulings goes against Guardian. So I think that they put it in place really quickly because Guardian only came out on the 21st of December. This has been sitting in the halls of the tax office for 2 to 3 years. So they needed to get it out, particularly when we're coming up to tax season, because you guys need to make some decisions around the distributions that are to be made and the allocation of going down with the tax. If there's an issue there, please feel free to contact us at Abbott-Family. We can help you out there. But Guardian, essentially the Commissioner's, all his arguments were knocked on the head. And that's primarily because when he set up this trust, set up the restructuring, it was all for asset protection, estate planning purposes. At that point in time, this arrangement where monies were put down to the bucket company, the trustee of the trust was a UPE, paid off the tax for the company, so that they're franking credits. And then what happened is then the company would then distribute back to the trust to wipe out, obviously, its underlying UPE. And then what would happen from there is then franking credits would go out to Mr. Springer, who is based over in Vanuatu, and that would just keep on going round and round. So it's quite an interesting case, and we're going to see what happens at the full federal court. But I just want to leave us on this one. I think is pretty important. This is straight from paragraph 152 from Guardian. For those of you who have got time, it's a really long case, really tough. Prestige Motors is a bit better to read, but again, you're looking around about 60 pages, and that's how my weekend was spent for that. So this is from
Grant, sorry, mate. I'm just going to jump off to the next one, but I just wanted to sort of reach out to all the members and everyone that's looking into becoming a member as well. Just reach out to Ben at lightyeardocs.com.au. And for our strategist members, we've got a special rate for the upcoming succession asset protection course, SEPEPA. So just please reach out to me. But Grant, this is a great session today for our members. We're also going to record a shorter version for you on just how to do it on the system, how to find the variation clause. And me and Grant are creating all these little how-to videos, just real dot points for you from these sessions moving forward with our marketing team. But great session today, Grant. Sorry, guys, I've got to jump off to the next meeting, but thank you so much. Bye.
Everybody, see ya. So I've got a couple of questions. Really good question, John. Actually, it's a perfect question. So for Francesca, wouldn't the second deed replace the original deed? So you use the variation clause number in the second deed for your third deed. Good question, John, is that my understanding from Francesca's question was that when she went back and checked that second deed, that it hadn't been, that there hadn't been a proper reference back to the variation clause in the first deed, which meant that second deed was dodgy. And generally what will happen is if you go to banks, what they do is they just ask you to do a deed of rectification, ratification. So it's really good to get all of that in line, John. But you're quite right. If it was, okay, so John is correct. So, so if you've got so wouldn't the second deed replace the original deed? So you use a variation clause in the second deed for your third deed. Absolutely. So if all your deeds have lined up, then when you come around to doing your third deed, which is, let's say it's a LightYear Docs one, then what you do is you use the variation clause from the second one, not the first one. So it's important. So thank you for bringing that to my attention. I took that question the wrong way. Copy of the slides will be after with this one. Dina, I thought that was a really good question. Dina or Dana, sorry. Should we have a clause on establishment of the trust of what the purpose of the trust is, or does that open up a can of worms? Not at all, Dana. I think that that's a brilliant idea. Having a look at Guardian case and the emphasis the court put on that was for asset protection and estate planning, I honestly believe I might actually put it in there, because the last thing, you don't want to be building these and saying they're for tax minimisation purposes. So if we're there doing it for asset protection and estate planning, I feel that if we're upfront with that, then we're going to actually start to understand. So remind me, Chris, I will put those disclosures in there. We'll be able to do a button, put that in. Again, this is part of that innovation. You know, we can fight the tax office, but again, I think the tax office has looked at what's going on, and essentially, you know, the distribution of the kids, the money goes back in, and then the parents utilise it. You know, from that perspective, the Commissioner is trying to knock that on the head, and unfortunately, he's got a super blunt instrument, which is Section 100A, and you've got to go through those 4 hurdles to actually get out, and there's like exceptions to all the rules. So preferably, it would be better for the government to say, well, this, if you did this, then we're going to start to look through it and review it to other people. But let's have a look anyway. This is from Guardian. And this is so on point for everything, and I think this is crucial. So for those in business, trade, or private practice in a professional or other occupation, this is us. Risk minimisation is not just a consideration at the point of embarking on such a venture, or even when while one is actively embarked on a venture, at least amongst the prudent. And Mr. Springer, because he was actually transitioning to retirement, so he'd already set up the trust. And Mr. Springer is a member of that class. It endures as a consideration of one transition to retirement and in retirement. One obvious reason for this is that the limitation periods for civil proceedings do not cease on an individual's retirement. The risk minimisation benefits of the limited liability company, either alone or in conjunction with discretionary trust described by Huey, J and Rippon, are not confined to the outset of the venture. So it's a good one if you have a look at what Dana's saying, is that when we're building this, we should have in line this risk minimisation. And remember, estate planning, that we use the trust for risk minimisation of family provisions claim. We're using this for our risk minimisation in terms of ongoing litigation. Also, at the other end of a venture, their employment does not necessarily bear the stamp of tax avoidance. More aptly, in terms of the language employed in the definition of agreement in Section 100A13, their employment, so when they mean employment, it's not their employment, it's the actual utilisation of these trusts and their structures, is not necessarily incompatible with an ordinary family or commercial dealing. So that, for example, if we're going into minimise and mitigate our risk from an asset protection point of view, particularly if you're using a leading member trust, and that's a really good question, probably we might want to think of, Paul, is that we're doing this to actually enforce and enhance that leading protection trust. In this particular case, for the reasons given, the incorporation of the bucket company, its appointment of the member of the eligible beneficiary, so as actually the shares were held by the trust, and the resolution to make a distribution of it to trust income reached nothing more than ordinary family or commercial dealing. And when we have a look at that, that's quite an interesting one, because that sort of blows away a lot of the stuff that was sitting in the Commissioner's guidelines. And I certainly, from a SEPEPA point of view, I'm going to be looking at Guardian and how that applies, because the Commissioner had obviously done a lot of work in this, because you can see it was on the 21st of December, and there's just a footnote there that basically says, well, Guardian's on appeal, and that was it. So we still need to look at everything in the light of Guardian. Will Guardian change that much? And look, I think it's really well argued, because they use a lot of high court decisions. So it's going to be interesting. I just think the section 100A is a really ugly section, because you've got to do all of these things. It's much the same as Part 4A. It's a very ugly section. Anyway, look, I'm sorry I've taken up a bit of your time. What I'll do is I'll send through these slides. I'll send also the link. I did this whole presentation going back in, I think it was September last year. So I'll send that link with you as well, so you can go through for those if you want to get a really good basis of trust, because trusts are where it's at. Just because we've got this one little tax issue, as I said before, it's not going to stop much. It just means we have to recalibrate our mind. That's why we want to make sure that we're really on top of it, and we make adjustments along the way, which is really important. John's come up with another one. If a child receives a distribution from a hybrid discretionary trust that can issue units, could the beneficiary use the funds to purchase those units as an investment for that child? Absolutely. So I don't see that that's potentially an issue, because we are getting in there. Although there is one little, I did have a look at one element in the draft guidelines, John, that I want to go back and check on, because they do talk about units and shares. So leave that with me, and I'll come back. So this is going to be an never-ending process. You know, I'd love to have your feedback. As I said, we've got a session coming up for SEPEPA members. It's our first one, a good 3-hour one. Look, I know we've slotted family provisions claims there. Whether we use or do a further deep dive on trust, I don't know. You know, really, we're beholden on our members. Please just send me an email to grant@sepepa.com.au or sepepa.org.au, I think. And then what I can do is, we might say, lay down some tracks as what we're going to do for our solution. And just remember, we've got in July, we're going to have our first ever SEPEPA conference. So that's going to be super exciting. And we've got some international speakers on that one. They're not coming, but they're going to be pumped around. But look, really appreciate all you guys coming on. There's our CPD. We've got our next course. If you've got staff who haven't been on before, and if you've got staff that haven't been on before to the course, put them on, and I think have a chat with Ben. There's a discounted fee for a second person from your firm. I'm also, which I think is important, at some stage, I would say in early May, I'll be doing my 3-day SMSF specialist advisor course. And really, I've learned so much over the last 3 or 4 years, particularly around families. And now, when we're looking at if the Commission is taking greater focus in on family trust, we can start to use, particularly around parents, start to push stuff through SMSF. So we're going to be looking at a lot of that. We're going to be on the road too, hopefully by May at that stage, so that, you know, I think this COVID is all drifting off now. I think probably people got bigger things to worry about. But look, really appreciate all you guys coming along, and we'll take a recording of this and you'll see that this afternoon. Anyway, it's Grant Abbott signing off, and have a great day.